Hello and welcome to the World IP Forum. Coming to you from Singapore, I'm Mark Laudy in the PitchMark studio. New risks, new challenges, and of course emerging solutions. That's what we're here to discuss in the next hour. As a platinum sponsor of the World IP Forum, we're very pleased to have you with us. You all know the situation well if you're a creative or an innovator. You have an idea, you want to pitch it perhaps to a prospective customer or a prospective investor or somebody else who you hope will like your idea so much that they'll buy it from you, that there is some sort of transaction that results from it. But in the end, what happens? The client decides not to buy, the investor decides not to invest, and you still see your idea implemented. And of course, if you're a creative or an innovator, you know just how painful that is. So in the next hour, we're going to walk through what you can do about it. What are some of the stories that you have, and also what are some of the solutions that the law and perhaps even the client side can offer? Joining me here in the PitchMark studio is Vernon Liao, who's creative director at Vital Images.
Right.
We're also joined by Nan Iliana, who's the founder of her own PR firm called Bridges MNC. On my right, we have Cyril Chua with us, who's director of Robinson LLC, a Singapore-based law firm, and Miguel Bernas, who's going to take up the boxing gloves on behalf of the clients, because after all, being a client in this situation is also not much fun. You're getting lots of proposals, some of which you didn't ask for, some of which are quite half-baked. How does the other half live? Is the question that Miguel is going to answer. He's the founder of Timberwolf, also a communications consultancy, and critically, Miguel's been on the client side at companies like Singtel, Yahoo, PayPal, MTV, CNBC, and others. So let's hear the story first. Vernon, you shared the story with us earlier. What a terrible thing that happened to you.
Well, here's what happened. I did a book project for a company that does trade books and such. And whilst they have an extensive library of images we can use and all that, this just wasn't something that was suitable. So what I did, because I also do photography, was I did a shot, an image, which the client liked a lot, and we ended up using it for the book cover.
Mm-hmm. So and you got paid for that, right?
And that was great, yeah. Right. So I got paid for doing the book design, right? So the photography thing was just something that I thought I'll do just to, because they didn't have anything we could use. So that was great. So that was done. Everyone was really happy. And then the next year it comes along. This is an annual publication. This time, the client requested for sort of like a tender arrangement. Something unique about this tender was that it wasn't fee-based because there was already a fixed budget. So you don't compete with another agency on the price. You're basically competing on the quality of your work. So what they feel is suitable for their use and all that. So what happened was this second time around, I didn't get the project, but I was also curious to see, what was it that they decided on.
The winning agency, what did they do, right?
Yeah, that's right. And I was shocked to see that they basically they reused the same image that was used the previous year, the one that I created, which actually they didn't have the authority to do so.
Right. So it wasn't the client who you pitched to, but a competing agency which the following year wanted to go for the same gig. They beat it, possibly with the contribution of your image.
That's right. That's exactly what happened. So they used the same image. They didn't even modify it or anything. They just added a white bar and put the words there instead, because previously it was just the image with the words on it. Mm-hmm. So it was clearly the same image. So I suppose there was a bit of a misunderstanding, perhaps, because they must have gotten the image from the client, and the client wasn't aware that this image, they weren't authorized to reuse it for other purposes.
So the client wasn't exactly off scot-free either, in other words. They must have got the image from somewhere, unless they scanned the book.
No. So they got the image from me because it was part of the book that I designed.
Yes.
Right. I guess they were unfamiliar with, that they were not, because they didn't commission me to take this photograph.
Yes.
So technically, or legally, they didn't have the right to reuse the photograph for something else.
And how did you feel in that moment that you saw the winning bid in the following year and said, hey, that's my image?
Well, I was disappointed that I didn't get a project, but then I was shocked that, you know, what was supposed to be a competition about creative content, you know, and they used something that I did. So that is another thing to, you know, talk about, right? Because how could I, you know, I presented new ideas, and then this guy used my image and he won the project, right?
Yes,
so that was
an old idea.
That was a bit
so what
shocking.
happened? How did you resolve the issue?
We did it very amicably, no lawsuits or anything like that. I basically approached the client and said, oh, you know, actually, you know, we did this last year and then, you know, you're not supposed to reuse that photo. So we reached an agreement. They paid me a token sum for the use of the image, and that was the end of it. And well, the thing is, what I like to do is to, because I also found out that a lot of people in this kind of situation, so it's good to be able to sort of have a perspective on this, which, yeah.
So you found discussing it with others helped?
Yes, in a way. I also learned that it's always good to have everything sort of clearly written down and, you know, in your contract and things like that.
Yes.
Us creative types, we usually are not very, you know, especially from a small agency, we don't have a big legal team or anything like that.
Or any legal team for that
yeah,
matter.
you know, we might just put a little, you know, clause in a quotation or something like that. We don't make the client sign some, you know, 10-page document or something.
Yes.
So this is, I guess this is something that, you know, we could be better at, you know.
Then Eliana, your story was even more dramatic because you didn't actually pitch it to somebody just took your ideas. What happened?
Well, it's a bit of both. So this was a pre-social media. It was around 2004. I was just starting out, and there were 3 people in the agency, including myself. So we had we acquired this contract, which was awarded to us by a local company. But the local company is actually a partnership with between an Indonesian company and a local entity. So the Indonesian entity back home has got about 30 to 40 outlets across the nation. So this is an FMCG, F&B business. So they sell a lot of food, snack items. And in Singapore, they didn't have that many outlets. I think they had only about 5 or 6 outlets in total. So we acquired we were awarded the advertising campaign. So we did that. They were very happy with it. And so they asked us to pitch for a mascot idea. So the mascot idea, the idea behind it was to increase sales. We can create it, we can make it into various things. We can make it into keychains, into notepads. You know, we can make it into 3D mascots for, you know, when kids come to their events, you can take pictures with them. They can incorporate them in the shop fronts of these shops. So that was the idea. So we pitched for it. So we designed it. We even created a small rough prototype, a 3D prototype for them to consider it. We created 5 or 6 characters. So it was pretty much fleshed out. All we needed to do was just send it to production, right? So the first thing that happened was the business in Singapore wasn't doing too well. So one by one, the outlets started to close down. And I think the main person of the company, the Singapore company, left. So we had no contact with him. He might have left the country because he's Indonesian as well, so we lost touch. And I decided, okay, that's the end of it. I'm going on a holiday. So 6 months later, towards the end of the year, I was on my annual Bali pilgrimage. And I went to one of the malls in Bali and I stepped in and then I just saw my idea literally littered around this particular outlet. And they made it into this huge, like human-sized mascot. They had keychains. Kids were buying it. You know, they were collecting. There were 6 of them, and they were given Indonesian names because it's in Indonesia. So I was like, wow. I didn't know what to do. I knew it was wrong. I went home with it, and I told my partner at the time, and he said, you know what? I'm going to Jakarta next week. I'll let you know if I see anything. And he went, and he also saw the same thing. But he's only gone to a couple of outlets. He said, I'm not going to even look at the rest of Jakarta because it's just too heartbreaking for me. And at the time, we were a small agency. So now we have 10-man team. But back then, there were 3 people on the team. We were doing everything ourselves. And for us to seek recourse from a legal team is going to cause more trouble and money than we had the energy or resources for. So what we did was we just bit the bullet and moved on. So that was basically the turning point for us, in the sense that, okay, we have to start pre-qualifying our clients. Who are the kinds of clients who have that sort of reputation? Then just don't play ball. And then that's how I decided to actually move into medical and healthcare, because it's a lot more regulated in the industry, and your experience and your industry knowledge is a lot more respected in that industry compared to, say, FMCG or retail, or all the other industries.
Yes.
Yeah.
So imitation wasn't really the best form of flattery for you at all, was it?
Yes, and that was before social media. Could you imagine? I had no words to describe it. Facebook was only invented in 2006, and it happened around 2004 before I set up Bridges MNC. So I can bitch about it, to friends. I could talk about it to other creative directors who are in the same shoes as me, but as to whether I can get any legal recourse, it was completely out of the question. It weighs too much on the resources we have at the moment.
Yes,
Yeah.
but it went further than that, right? You had URLs, websites. You had a dispute over a Google Maps location or Google Business location. I mean, there seemed to be a whole lot of additional things involved in this story.
Not at the moment. I think they were using it they were kind of using it to do. To kind of dress up their website. They were doing lots of, you have to remember, this is back in 2004, like Facebook, social media was not yet there. Google Maps, I think, wasn't even invented at the time.
Right.
So in terms of online presence, it was really very minimal. They had some of it online, but the main thing was really the fact that they were making money off it. People were
Yes.
buying their snacks and collecting their items. They were increasing
keychains, you were saying, so they were
Yeah.
actually transacting with
They
this.
were transacting with it, yes. Transacting with it. People were buying more of their stuff because they wanted to collect the items, you see. So, that was the main thing. We could have, there was a clearly like loss of revenue, potential loss of revenue there.
Yes.
And I met a couple of friends who were legals, and they were saying, yes, you could do this. And I'm like, I'm in Singapore, they don't even have an entity here.
Yeah.
What are the chances of me going to Indonesia, where it's a lot more of a cowboy town compared to Singapore, legal system wise, to gain any recourse, you
Yes.
know? And the office has shut down, the outlets have closed. So what is my channel to get back?
And chances are, those of you watching, you probably have similar stories of woe. Maybe you're an architect and you designed something for a prospective client. They didn't pay you for it, and in the end still built the extensions to your house, perhaps. Let's get some legal recourse from Cyril Chua. What's your reaction to these stories?
Well, it's actually pretty common, what I've heard. I mean, I'll just take Vernon's case. I mean, that's a classic case of misunderstanding, right? Now, Vernon, as the creative person, you own the copyright to what you created, the piece of artwork, right? The photograph, the image, right? But unfortunately, for a lot of your clients who commission the work, they think they own everything, right? And so if you put in a book for them, oh, okay, all right, I commissioned this, it's mine. So that's the classic thought. No one really picks up the legislation, oh, this is the Copyright Act, oh, it belongs to the photographer. No, they don't do that, right? They just think that I paid you, it belongs to me. They think it's an orange and an apple you buy over the marketplace. So I guess in Vernon's case, it is really important to be clear at the onset, where Vernon said, here, I did this book. Now, well, we had problems finding the right image. And I took this image for you, and note, it's only for this book to be used on this project and no other.
Yes.
And that has to be communicated to them, right? And sometimes if they're not aware of it, they think, oh, okay, everything in here belongs to me. I could pass it to the next publisher. I could use it for posterity. Well, I mean, so
yes.
That's important.
And you've actually got the image here. Why don't you call it up on your iPad?
Yeah, well,
But that's obviously, in the eyes of the law, is that an excuse to not know
No,
the law?
it's not an excuse. But you see, this is the reality of intellectual property law is that it's one thing to have the law on your side, it's another thing to take the case to court because of the cost, right?
Right.
Would Vernon be going over to the jurisdiction of his clients and start the litigation, and how much would it cost? How much would he get back for that? And when you work out the maths, it's just not worth it. And then you just struggle. Oh, it's a hard luck story. But it feels very bad. It eats on your soul, and years to come you feel like you got cheated. So I guess to avoid all that, put it in black and white, made it clear to clients that, look, it's only for this edition and no other, right?
Yeah.
And that comes to the Nan's case. Right now, I would feel really aggrieved if I'm in Nan's position right now. What I do see is a clear case of infringement, right? Nan created the designs for the mascots and the 3Ds and the whatnot, and they just took it out from Singapore, took it to Indonesia, and rolled it out. Now, prima facie, that's copyright infringement, and Nan could sue them. But then again, Nan was being realistic. Am I going to take a case in Indonesia? How much am I going to spend to sue a multinational, a big company with like 40 outlets, 30, 40 outlets? What I might do or advise Nan is, well, get an Indonesian lawyer to at least send a cease and desist letter right to them and start the negotiation going. Maybe they may say, okay, we'll pay you something. Please go away and don't disturb me again. Right. They might do that. So, or they may tell Nan to just go off, don't come back again, right? And then that's when Nan will have to make the difficult decision of either to litigate in Indonesia or to drop the case. So now that is one of Nan's case. Now, assuming it's more than Indonesia, you have a similar incident happening in India or China or elsewhere. Now, what are you going to do? Are you going to go to every single country to litigate? That makes it, that's part of the problem with the IP law, right? You may have the law on your side, but the cost of enforcement, it's sometimes a threshold that is just too high for small and medium businesses.
Yes. It's 16, 17 years. Is it too late?
No.
No?
No.
I don't have the prototypes anymore. We've just closed it. We just closed the doors on it. Yeah, come to think about it, I've nearly forgotten about this incident until I got a call and somebody asked me and said, have you had an incident like that? And I'm like thinking, actually I've had several. I mean, in Singapore, but it's just like talking to your therapist. Like you don't realize that you actually have gone through trauma until you're told to recall it. So
yes.
This is the biggest one I've had so far, and the most significant one.
Yes, and
yeah.
that pain is still coming across.
Yeah, it does come up. I mean, the pain is still there. I had to go for therapy for it. That's why I brought her up. So, yeah. But the thing, me and my art director, we're no longer in touch. So he actually owns the copyright. I mean, I'm just the person who executes, who helps with pitching of the project. So literally, I think that the copyright really stays with him. It's not mine. Yeah, and he should be in this chair right now. Really.
Is there no statute of limitations in this case?
For infringement, I believe that it's. I have to check in Indonesian law, but I believe that it's beyond the 6 years.
6 years.
I mean, they may argue that you have acquiesced to the use of it. Mm-hmm. Right? That's one of the arguments.
What if she actually then took her own mascot and all those images that company
mm-hmm.
produced and put them on her own website? She kind of steals the idea back and says, look, this is what we produced and here it is in Indonesia.
That would be interesting, actually.
Well, then you just basically challenge them to take you on, right? Now, well, there'll be quite a fight.
Yes.
Because the other argument which they'll try to raise will be under law of passing off. They claim that they now own the goodwill to the mascot, and by using the mascot, you are trying to pass off their goodwill as yours. So you may own the copyright, but they may own the goodwill to the mascot. That is how interesting IP laws could be. So you're talking about two areas of the IP law.
And in particular, given that it's Indonesia, let's just say another jurisdiction. Mm-hmm. Does that automatically make it more difficult? Or are there some jurisdictions where coming from Singapore, actually you're going to have an easier time?
Well, generally, if you're looking at the Commonwealth jurisdictions, it would be easier because there is uniformity of the law, and there is also the reciprocal enforcement of foreign judgments. So you find that it's easier to enforce, and the procedure is, I would say, 80% similar. But when you're looking at Indonesia, you're talking about a civil law country where the systems are quite different. While the IP law is again quite similar, but the enforcement process and the costs, that could be quite a barrier
Right.
for enforcement.
Okay, so we want to obviously flesh this out in a little bit more detail.
Sure.
Unfortunately, we can't wind back the clock now. I wish we could do that for
I
you.
wish I could do that too.
And for you watching, obviously, if you have similar stories, you probably would also prefer to wind back the clock on some of these things. But I do want to bring Miguel into the picture here, because for every time you pitch, clearly you would also want to have somebody to pitch to. And it's important to see how the other half lives as well, because on occasion, Miguel, in your role in digital marketing, in receiving creative pitches, that's also a difficult position to be in.
Yeah. So first of all, because I work as a consultant now, and because I've a good chunk of my career as well has been on the agency side, I do have to say that I feel for you guys a lot, and I've been in similar situations. I've been on both sides of that equation, right? And so some of that is familiar, and if pressed, I could probably think of a couple of grievances myself that where I feel I'm the one that's been wronged. But I promise today I'm going to keep my client hat on.
Yes.
So there's a couple of things, right? There's a couple of things that do come to mind, and the first thing is that I think it's fair to say that for the majority of these transactions, people on the client side come to it with no malice. Right? Nobody, in very, very few circumstances, if you have a situation where the client is openly doing a pitch specifically with a view to say, I can't wait to see all of these ideas I'm going to rip off, right? That's not really what generally happens.
Generally, I have heard of some stories, though.
There are some stories. I mean, they're not impossible. They do happen. I happen to know a few of them where that's exactly the case.
Yes. Lock the doors. We'll get Miguel to spill the beans.
But for the most part, people go into these things with no malice, with the best intentions. Now, what often happens is either through a combination of naivete, of ignorance of intellectual property laws, or just outright incompetence. Little lapses can happen. Mistakes can be made, and sometimes things just sort of slip through the cracks, right? So that also happens. But I also think a lot of the time, and again, if I can just kind of defend the process a little bit on behalf of the clients, very often what happens is that the people putting forth the idea also don't do enough to protect themselves. So if you look at client work, whether it's a big corporation with employees, or it's a big corporation who has a contract, say a retainer contract with an agency, or even a photographer, or production house, or something like that. The agreements are very clearly written out, where they say in this exchange, in this transaction, everything you produce belongs to us, right? It doesn't, you don't retain any rights or any of that stuff. And so the clients are typically the client side is very, very lawyered up from that point of view, right? Their interests are very clearly represented in black and white. And unfortunately, a lot of agencies and a lot of creative people tend to go into these transactions with nothing more than a lot of trust and a lot of just sort of, confidence in industry practice, rather than something that actually is in black and white that protects themselves. And I think part of the problem also is that there isn't enough of that discussion from the get-go. Where as Cyril said, when you go in, you're saying, okay, I'm giving you this, but let's be very clear about what you're allowed to use it for. And unfortunately, in a lot of cases, especially at the pitch process, none of that is defined, right? The industry practice in Singapore very often is that it's kind of a given that the agencies are asked to pitch. They're asked to pitch for free. The agencies are asked to invest their time, and they put forth their best creative ideas. And they kind of have it to take it on trust that their ideas won't be stolen because nobody wants to be accused of ripping off ideas, or word will get out in the market. So there's a lot of stuff that is legally protected, but there's also a lot of stuff that is just sort of done in practice, right? That's just sort of accepted behavior.
Yes. Well, how would you do things differently, Vernon, if you had your time again?
Well, I think like what was mentioned earlier, clear communication is the key, right? But there are always all these gray areas. Let me give you an example. I do a lot of corporate photography. And for one of my better clients, they made me sign an agreement that I cannot use any of these photos online. That was very explicit, as in online. So bear in mind that this is a photo of, say, someone standing in a boardroom. So there are no logos, nothing to identify the name of the company. So actually, I've got a question, right? Is it okay for me to then still, because I've done a lot of good work for this company, and obviously I want to show it off to the next potential client, right? So what I've done as a workaround is I've put it on a PDF and a portfolio, which I then send privately to a potential client or somebody who wants to review my work. Am I still in infringement, or is that okay?
It depends what exactly you signed, right? If they said that you can't use the photograph in any form or in an electronic format or send it to anyone else, then you would clearly be in breach. But it's probably easier for me to advise if I were to look at the agreement.
Right.
So I would look at it this way. I would seek my client's permission. Look, I need to do pictures. This is my line. This is my role. Would it be all right if I were to put it in my portfolio where I could show some of the prospective clients of the work I do? And most of the time, they are reasonable, right? Now, what you see is when you do work and they make you sign this standard template of an agreement, basically they ask for your soul and everything, right? So that's
You're
how
the one
it
who
is.
writes these agreements.
Yeah, unfortunately, I confess
That's
that
why
I
he
do all
knows
that.
it inside out.
Yeah. So, but ultimately, when you go into a project, you try to anticipate what you need out of it. Like, okay, it's a good project, I would like to show it. And you would also want to anticipate what the clients want of this beyond what is the intended project. So you can try to do grace in the crystal ball and look, okay, they're going to need it for this. So be prepared that they will probably take this and use it for that, with or without your permission, right? But you know that you may want it for your portfolio.
Right.
Talk to the clients and say, look, I think it's a good piece of work. I just want to use it to show off my portfolio. I will not put it in the website or whatsoever. It will be just privately to some of the prospective potential clients. Right?
Yes, but the thing is that chances are you probably feel, I don't really want to bring this up. I mean, I want to work with them. I don't want to create any speed humps along the way that might make them say, oh, well, if Vernon's going to be like that, then we're not doing it. What do you what's your experience from the client side? If somebody like Vernon, like Nan, was to do what Cyril suggested, would you then say, oh, this Vernon sounds like trouble, I don't think we should work with him?
Well, again, if you're taking a photo of somebody in the boardroom, right? I mean, first of all, presumably you're taking multiple photos, right? And then there's the one that the client decides this is the one we're going to put on the website and all of that. Again, it's going to be a question of what exactly is in the agreement about what the client is paying for. Are we paying for the whole? I was going to say the whole roll, but we don't have rolls of film anymore. I'm aging myself there. But are we paying for the whole batch? Are we paying for your hours? Are we paying for whatever? Or are we paying for just the one photo that we use, right? And again, with the agreements, usually they're pretty explicit about that. And again, I hate to keep pushing it back to the creator, but part of the onus also is that just to protect yourself, you say, okay, the agreement is you pay me this much, but that's for the one photo that you've selected out of the 20 that I've shot.
That's a good point, actually.
Yeah.
Yes, but if you did that, hence my question, would you as a prospective client think any less of a supplier, of a creative, who all of a sudden raised heckles and didn't just sign the templated agreement?
Okay, me personally, not at all, and that's because I completely respect intellectual property.
What about you impersonally?
And you're a decent person, that's what it is.
Indeed, but what about if at large?
Well, I mean, it depends on. I suppose that part of it depends on how you put it. Part of it depends on how reasonable you're willing to be about pricing and stuff like that.
Right.
And at the end of the day, that's going to be a big part of the discussion, right? How much for how much?
Yeah.
If the client feels like that's a ridiculous amount of money for a hell of a lot of conditions, then it's of course human nature for the client to think, wow, that as a vendor, as a partner, that's quite a bit of demand for very little ROI on my part. But then again, on the other hand, if it's reasonable, if the request is reasonable, and if it's no big deal to the client, it shouldn't be a.
Try this one in, right? Sign the deal, get the job done. When you want to use that picture for your other portfolio, to them and ask for permission.
Right.
Right.
But
We
here's the
note
thing, that would be the right sort
Yeah.
of steps to take.
Yes.
The reality of it is the person that you probably, the client on the client side, the person that I work with is probably a marketing head or something, and never someone in legal, for example. It would be then troublesome for this point of contact. For
Okay.
him or her to then have to go back to legal, and legal's just going to say no.
And it takes 3 months, right?
Yeah.
Okay. So check with that person. He says no. You could recreate the picture in a slightly different
Right,
boardroom,
right.
get new actors, put
Right.
them in there, take a picture. You own the copyright.
Right. Actually, what Miguel brought up earlier was also a good point, because what I did was I did use a different photo that was not the one that was sold to them.
In the PDF, you mean?
Yeah.
Yeah, in the PDF.
Right.
So, and people move, right? People move companies and all that. So long as I have consent from the person that I'm featuring, I feel that I'm covered, and I don't mention, because that sort of restriction was actually mentioning the company's name. So I cannot tell people that this company is my client. It's a funny rule. It's the only company that I've come across that ever says that I cannot tell people that you are my client.
Okay.
Yeah.
Nan, jump on in. Does it get any easier to do what Miguel said, like to bring it up openly when you're a larger company? Does it get any easier in a specific industry that you're in, where you can then feel comfortable about, being open and honest about some of the conditions?
Well, for industries that have been used to regulation, like the medical and healthcare industry, they are a very highly regulated industry. So in the course of us rolling out public relations campaigns, whether it's for disease awareness or whether it's for the launch of a new drug, you almost always have a regulatory person sitting in. You almost always have somebody sitting in there telling you, you know what, you can do this, you can't say this, because we are bound by the rules and regulations of the local ministries, the health ministries of each country. So in that situation, I'm very, very comfortable. I can negotiate with my client, like, look, okay, this is only for an internal campaign, let's say a sales campaign for a certain brand for this pharmaceutical company, but it's only for you. It's not for other departments to share. And that sort of thing. And when it comes to sharing, let's say, material to potential clients or prospective clients, what I normally do is that I don't even PDF it. I will only show it to the prospective client only if I'm in the room with them.
On your screen?
Yeah,
on the
my
tablet?
screen it's a one-to-one thing, and it kind of is. It is kind of the practice even for medical practitioners. So they can't show before and after photos on TV or on in ads or anything of that sort. But when they're in consultation with a patient, they can show certain things. So in that particular setting where the industry is regulated, you have to go through certain rules and regulations. Like for instance, when you want to run an ad for, let's say, a supplement, or whether for as a drug or whatever it is, you have to go through regulatory approval. It's a very basic thing. So I, as a business owner, feel very comfortable with that kind of infrastructure, and I'm happy to be able to explore my ideas and negotiate terms and conditions. But when it comes to other kinds of industries, when you're working with an SME, for instance, which was my case in Indonesia, when you're working with people who are not even sure what they're buying an idea, it's an intangible thing. But it's an intangible thing that only through our funds and resources we can actually make tangible into, like keychains and notepads, etc. So you have to first educate them, what exactly are you buying from us? So it is only with my limited experience in agency, I'm putting my agency hat on when I was with the bigger agencies. Like there are three things when it comes to, when you're pitching to a client, there are three things. There are the creative fees, there is a production fees, and there's a licensing fees, okay? How the perception of IP or the value of IP gets eroded is that somebody like me decides to quit a large organization and say, you know what, my client's charging, my boss is charging the client $10,000. I can charge it for way less and pocket most of the money rather than having to draw a paycheck, right? But the thing is, they don't realize that by doing that, they're actually eroding the value of IP, because they don't realize you're not just being paid for creative fees. For instance, you have a logo, or you have like a mascot idea, and let's say you want to print it on like 200,000 paper bags for a limited period only. How much are you going to charge for that? There's also the licensing fees. Like, we are familiar with, say, using, like Microsoft. We complain about it, but we still pay the right for the rights to use the software for Adobe, for instance. So that has to be instilled. And the thing is, the big agencies don't always tell their staff, this is why we are charging so much. It's because first we have these three things: the creative, the production, licensing, and then we also have multi-territorial use. It's not just in Singapore. I'm going to take this to Philippines. I'm going to take this to Indonesia, etc. All the staff are thinking is like, my God, my client is charging that. I know how much man hours is put into it. I can charge it for less. So by not educating people that's that value, when you pitch to a client, that's when you erode the value of IP. That's when you do not feed or help the ecosystem to grow. I think that's really the thing.
Is there a case, in fact, Miguel, to say that when you have an agency or any creative, even a one-man architectural firm, let's say, if they come along and push back on the IP, does that actually heighten your perception of them? So rather than say, oh, gee, he's too much trouble, do you actually think, wow, he's really professional because he's punching above his weight?
Yeah, I would say so. I mean, especially if they're very clear about their understanding, it demonstrates that they know the industry very well. It demonstrates that they know how to work with the big boys because they fully understand what laws protect them, etc. And again, I'm speaking from my perspective. I don't know if everybody thinks the way I do, like as a client. And again, I'm very sympathetic to people who are creators and people who come up with all of these good ideas. Now, if for me that were to be the case, it definitely would not reduce my estimation of the agency or the creator.
So I'm totally in agreement with Miguel, because the last thing Miguel wants is that someone rip off another person's IP and sells it to Miguel, right? And then later Miguel's clients will be stuck with IP infringement lawsuit. Now that would be the nightmare scenario for Miguel, because he's the one who co-shared the IP before I pass it to the clients. So you really want some a creative person who is aware of IP laws.
And not just on the agency side, as you were saying, Nan, right? That the people creating the IP, but also on the client side. In your experience, was there a lot of education on IP on the client side?
No. And that's where I said earlier, it could be a combination of ignorance, naivete, or just outright incompetence, right? Because unfortunately, a lot of the time there isn't a lot of education internally among, say, marketing people, especially, because they've got other things. I mean, there are templates and there's contracts and stuff like that they're used to working with. But I'm willing to bet you, like, the average junior marketing person would never have read every single word of that contract, right?
And most marketing people are not really aware of what they're dealing with. So they don't come off knowing, they know what kind of man hours is involved in a certain project. They know what are the bolts and nuts and bolts of a project. But they don't really necessarily know the legal framework for which something can come to existence and something can be protected. So I think that is the first step. If we can have, like, we can organize something where marketing executives, whether you're from the public sector or the private sector, can come together and be educated about these things. And then, I think it'll be better for everyone, because it feeds into the ecosystem. You help the ecosystem to grow, and you have better ideas. What happens is when you don't feed the ecosystem, then you have people who are just disillusioned with this. I'm just going to sell this to my client and give my files, hook, line, and sinker, and be paid $500 for something that took obviously hours and hours and hours of brain juice and having to put it into action, into intangibles. So and then people who go into it are not really being at their best.
Yes.
So when you don't feed the ecosystem like that, that's what happens.
How do we solve this problem for Vernon? where he's a bit scared about raising the issue of contracts because, after all, it's okay for industries like pharmaceuticals, which are so heavily regulated. The lawyer is sitting alongside you, you were saying. But in Vernon's case, if you then had to, like in an uneducated state about the legal issues, then had to bring your lawyer in because the supplier, the creative, wants to put something else into the contract, how would you respond?
Well, first of all, I think as much as possible, everybody, both on the creative side as well as on the client side, wants to avoid as much as possible having the lawyers involved.
Of course.
Right? Nobody wants to have the lawyers involved as much as they can help it. So I think, you know, I think given that, a level of awareness on all sides is always going to be better. People are a little bit more conscious about it going in. And again, you know, there's again what you're entitled to do legally, and then there's what is the industry practice. And I think, you know, just touching on Singapore specifically, I think there's a lot more room for growth in terms of the industry practice. One of the things that I talked about earlier is that there's a level of naivete where people just sort of go into a transaction just on a kind of trust that this is what's going to happen, right? And you know, if there was a little bit more awareness, but also if it was more of an industry practice, for example, as you're giving your idea or sharing something with the client, there's a way of verifying, hey, I'm giving this to you, but just so you know that there are, you know, in addition to you and I, there's another party that verifies the fact that I've given this to you. There's a record that I've given it to you. And therefore, if ever there really was a malicious intent down the road, there's a natural deterrent that people are aware of, right? There's a deterrent that somebody's going to think twice, less so because he's afraid I'm going to get sued, but more so because this is going to look terrible for me by reputation.
Yes, and it really is down to the individual, not just because you're dealing with a multinational. It's the individual who you deal with, doesn't it? That makes all the difference. Well, I'm very pleased that we do have the lawyer here with us in the room, Cyril Tra. And by the way, if you would like to add your comments or questions, suggestions, please do so in the comments box next to this video. Cyril, you've listened to a lot of this discussion. Any immediate reactions before we get you for some free legal advice today?
Well, I mean, the key point is that we are sometimes IP users and we are sometimes IP creators. So we play both the roles. And even as me, the lawyer, I could be on the receiving end sometimes. I mean, a little anecdote was, I took my wedding shots with my wife. Yes, I have a beautiful wife. And within a few months, I saw my wedding photos being used on the roadshow. And then I realized there's nothing I could do about it because I don't own the copyright. So these are some of issues that even as lawyers, I mean, as much as you have a lovely wife, but you don't want your wedding photos to be displayed in all the road shows. But
yes, especially if you're not in the photo at the same time.
Yeah, precisely. So there was nothing I could do, right? And I mean, this is just an awareness. I think the way moving forward, as what Jan had said, is that to educate the sector, let's get everyone in, and I'm more than happy to conduct pro bono talks to the industry so that there's a greater awareness of IP, what you can do, what you can't do.
And we have another 15 minutes of that. So let's perhaps knuckle down some of those specifics.
Sure.
Because you said those magic words earlier on, it depends.
Yes.
You know, the fact is that if somebody was to pitch to Miguel, you know, if you were to pitch a photo to Miguel or perhaps another mascot idea. Now, clearly you had prototypes, you had a variety of designs, you had, in other words, you had some clear evidence of the idea. You had a photograph, you had a whole book, presumably also email correspondence, all sorts of things that then substantiated that there is a real serious pitch going on. But Miguel, sometimes the pitch is actually much more half-baked, right? Have you ever received like a handwritten page of notes and that was supposed to be the idea?
Yeah, and then there's the unsolicited ideas, right? I mean, maybe less so in a sort of creative agency context, but more so, for example, angel investors all the time get approached by people with clever startup ideas.
Business plans.
Business plans, yeah. And you know, in a lot of cases they're unsolicited. In a lot of cases they're elevator pitches. In a lot of cases they're the level of documentation or is actually very sparse, right? And so it makes it a lot harder to argue that idea was A, entirely original, and B, entirely mine, right? Or entirely yours. And that's always where it gets, I think, a little bit difficult. Again, as a client, I've been in a situation where, I've sat through pitches where agencies actually come up with very, very similar ideas. That's kind of a long way from actually seeing your character come to life inside a retail outlet. But it does happen that there are agencies that come up with very similar ideas, sometimes even similar, even almost identical taglines from two different agencies.
Really?
Yeah.
And they had no idea of the other?
No, one had no idea of the other.
Can I jump in here, please? The one thing that agencies regularly have to deal and contend with is that the people on the side of the client do not always give very good briefs. Their briefs are equally sparse. The briefs are very scanty. They might show you certain things that they like. They might change their minds. It becomes a subjective exercise. It becomes a matter whether do you like purple. Okay, the boss doesn't like purple, we'll have to change that into blue. And when we started building the brand for Bridges M&C, I was the founder of the company. And although I was advised by my designers, I was advised by people who were in the industry, it all boils down to me because, I am signing the check, you see? So it becomes a subjective thing. So if you don't define the parameters of your brief to such an extent that you can actually make something, create some concepts out of it, then it becomes very difficult for us to respond in kind. So if you're disorganized from the client's end, and lots of clients, no matter how big or whether you're from a big agency or a small or a medium-sized agency, a lot of them do give a lot of half-baked briefs. So I think that has to start, giving proper briefs, fleshing it out as much as you can, so that it doesn't just become like a competition of whether you like this more or not. Whether you like purple or whether you like green better. So but
whether
a
it
lot
actually
of times,
meets the criteria.
whether it meets the criteria and whether it ticks all the boxes. Because a lot of times, when it comes to, say, creating corporate guidelines and all that, it boils down to exactly that. Do you like purple and blue, So we were, this is many years ago again, so we were working on, like a mailing, a kind of a mailing campaign, and the client was saying, okay, do not use blue and red because that's very typical mailing associated with mail, this sort of thing, So we gave them all sorts of colors, but they returned to the same thing, blue and red. And I'm like, okay, so look, it should not actually, we should be able to I think clients should be taught, if they don't have the skills for that, they should be taught and they should learn to step back from what is required and create a brief that all of us can act upon in a way that's effective for everybody.
You look like you've had some experience with this
too. That's something
too.
I struggle with a lot as a designer because, like you said, I'm the client, I want to call the shots. That is something I think about a lot, and I think it's a bit of a cultural thing. I think generally in Asia, there's this client is always right mentality. I say if this thing needs to be red, then it's going to be red, even though it should be blue, for example. So that's the thing. I find that my best work is produced when my clients trust me, and then everyone's happy because they trust me to be a professional. If I tell you this thing needs to be in a certain shade of green, then that's my professional opinion. That's what you're paying me for.
But hang on a minute. You're not saying that it has to be more specific. You're saying it has to be less specific.
No. What I'm saying is, I'm touching on a point about the fact that a lot of clients, they have this mentality that they call the shots, right? Even though I'm hiring you as a professional, you should be telling me what works and what doesn't. Now, back to that whole thing about ideas, how it's actually very, very common, even at the highest levels, people sharing similar ideas, right? I'll give you one very, very good example. Ford motor car, right? I'm sure you know what the logo is. It's a blue oval and Ford, right? Now,
with a little pigtail on the F. Yeah.
Carrier air conditioning has a similar oval in the almost same shade of blue with a word in the middle. And if you put them side by side, I mean, there is some case of argument about design, copyright, and so on. And that's just one example. There are dozens.
But thankfully, they're not in the same business, which is why we also have Lexus biscuits, but only one Lexus brand of cars.
Right.
Yeah.
But you have a lot of issues about, these kind of things. So there's always that chance of people having similar ideas.
Okay, so Miguel,
Yeah.
should you be more specific, have a more fully baked pitch request RFP, or should you just say, do what you guys feel like because we trust you?
Well, okay. So speaking as somebody who's worked for a lot of big companies on the client side, there really is no excuse for a poor brief, and that's like if there's like one sin a client, somebody working on the client side can commit, it's that if you put together a bad brief, and there should be no reason whatsoever why you would ever put a bad brief down.
Right. So, Cyril, back to you. And the fact is that, if you have, let's say, you're representing Vernon or Nan, they both claim to have been the one to come up with a particular tagline or a particular logo. He's a bit young to be designing the Ford logo, but you know what I'm saying. Then how do you then go and approach Miguel, who says, but come on, I didn't ask for these different briefs, and I can't help that they're so similar.
Well, I think the biggest problem is always proof. Right now, Vernon would have to show that this is exactly what I put to Miguel, and he ripped off my idea and he used it. So it comes down to proof that he need to show that this is on this day we met up. This is what I gave to him, and this is what he had reviewed, and this is what happened 6 months down the road. He ripped off my idea.
Right.
Now, Miguel will have to again say, it was a similar idea I received from Nan, and he would have to prove, nope, on an earlier date, Nan came up with this, and and on this day, Nan came over, this is the brief she showed me, and if you look at it, this is precisely the idea that was conceptualized by Nan and finally produced 6 months down the road, and that is a lot more similar to the final product than Vernon's idea. So that would be Miguel's counter.
Is there a threshold at which you would say, okay, clearly prototypes were produced, clearly there's a lot of work gone in. Where on that spectrum would you say, okay, there is not enough, right? I mean, would a 5-slide PowerPoint deck be enough? Or would you say, no, it has to be 10 slides and it's got to have this and this and this information?
No, a lot depends on the substance. It's not so much of 5 points or 10 points,
So
right?
where do you draw the line between enough and not enough?
So what you look at is that is what is described sufficiently to create the final product.
Described in words, in drawings?
It could be in drawings, it could be in words. I mean, if I give you a really vague idea, I'm going to have a singing competition and we'll get the viewers to judge. And a year down the road, there's American Idol, and I say, hey, that's my idea, you stole it. Now that's going to be a hard argument because I gave a really vague idea and someone conceptualized it and did something else. Now, if you could put together an idea which someone could look at it, oh, that's the method, that's how is it, and that's the final outcome, then you would have a better case if your idea is ripped off, as opposed to something vague.
So the more specific, the better.
Yes, of course.
And obviously also because we all know that you can't protect ideas, because as you correctly said, they're intangible, but you can protect the expression of the idea. What are some of the better ways to do it, rather than just, let's say, a page of bullet points or a drawing? What are some of the more innovative ways that you've come across?
No, I think the usual industrial standard is to protect it by an NDA, unfortunately, right? You can't copyright an idea because the copyright protects an expression. So the idea is to, well, give you an NDA, and Miguel, could you sign it? Of course, Miguel will sometimes be quite worried that if he is to sign all the NDAs, he might end up in litigation should he not use any of these ideas but some similar ideas. So this is where the industry needs to find a balance between trust and what is reasonable.
Okay, and because you're also on the litigation side, you actually chase people who your clients say ripped off ideas. How much of the work that you do is, let's loosely call it legal? How much of it is persuasion, influence?
Well, if I may say, 90% is persuasion, because no one wants to see the lawyer, and even less wants to go to court to fight over this, because it's a lose-lose scenario for everyone except the lawyers
Yes.
to get their fees, right? So I guess if you come to the table with sufficiently strong evidence that your ideas are ripped off, or you come to the table with sufficiently strong evidence to show that no, you did not rip off the ideas, but it was from another designer, then we can come to a compromise and an agreement where you resolve the matter. And I think one of the better examples was Vernon's first example about the image and how he could resolve it with the
Yes.
user of the image.
How did that feel, actually, Vern? Did you have any trepidation?
Well, it's always, everyone wants to avoid conflict, right? So it's always very, I always say there's a difference between a reaction and a response, right? So the reaction when you first see something is, wow, But then I think you got to give yourself time and you respond. And I think always, like what Cyril advised, do the right thing, go the right way. And sometimes, unfortunately in N's case, it's really too much to have to go to a different country, and
Did you actually have those phone conversations with them and do what Cyril suggested to kind of just talk them around before you engaged the lawyer?
No, we didn't even engage the lawyer. They are no longer in Singapore. This was in before.
So there was
it's
nobody you could
before.
call?
So there was nobody I could call. The offices have closed down. All the 5 or 6 outlets that they had here had closed down. There was really no recourse. The only recourse for me would be to go to Indonesia and track them down there and find a lawyer is one thing, but I have to first find the office and a point of contact there that I could address or air my grievances to, and I didn't even have that.
Yes.
You have to remember this. This is actually pre-Facebook, pre-social media. So it was not something that I could have done easily without actually, like spending more money. I have to buy plane tickets. I have to engage with a lawyer. I have to pay him by the hour if I had to do that. So and that time that I'm taking away, I'm engaging with the lawyer, etc. I'm not working. I am actually not engaging with the work that
Yes.
pays the bills, that pays the company. You see.
But you also mentioned, Vernon, that you had some reluctance about engaging a lawyer. What was the key worry in your mind?
Well, that's the thing, right? You always have to look at your objective. What do you want to, what is it you want to get out of this situation? Do you want to get paid? Do you want to, what is, once you've established the objective, then you sort of decide whether or not, whether a phone call will do. Also depends on your relationship with the client to begin with. You have a very good relationship with the client, sometimes it really just is a misunderstanding, which I believe was the case.
Okay, so Cyril,
Always avoid the lawyers, like what you said earlier. So.
I am fully with you 100%, Vernon. When there is a conflict, the first approach is, if you know the person, pick up the phone and
Yes.
talk it out.
Yeah.
Right? Why get the lawyers? It's a lot less antagonistic,
Yeah.
and they will be more open to alternative solutions. Oh, I can't pay you for this, but I could try to give you the next project, which might be something bigger, or maybe you give me a discount and I'll give you that. So that's where the negotiation comes in. It's only at the last resort, and and you would still get these cases where you find that someone is totally hardball. Then perhaps pick up the phone and check what is your rights.
There's actually
get a hardball lawyer, right?
Sorry, there's another recourse here, and it comes back to what Vernon was saying about getting paid, right? So the other, this is something that really has only been discussed in the last, I don't know, feels like sort of the last 10, 12 years or so. And that's this whole idea of pitch fees, right? So especially when people are being asked to respond to an RFP, some clients or some clients are willing to pay pitch fees, and some agencies are also in a position to demand pitch fees. And that kind of changes the equation in a bit, because on the one hand, it gives the client way more rights because they're paying for the ideas. It also protects the agencies because, again, they don't have to completely write off whatever is the time and investment that they put into it.
So they feel a certain sense of ownership of that.
Well, I don't know if ownership is the right word, but if you feel like, look, we're going to burn 40 man hours
The
into this
compensation as
project
well. Yeah.
just to be able to pitch for the business, then at least we get compensated for it.
Yeah.
And then there's an agreement that, well, whatever you submit, the client then owns, or the client has rights to. And even if you don't get the full business later on, the agency can tell themselves, well, at least I got paid for that period of, you know.
But you can see the grey areas that we're now wading into.
Yes.
Are you now saying
absolutely.
the pitch fee is for the creative, for the production, or well, possibly not production at this point, but maybe it's the license? Is there a more definitive?
Again, it
process?
depends, right? It depends on, and I imagine a lot of these things are structured in very, very different ways. The other thing also and there's arguments, by the way, there's pros and cons to this kind of argument. There's pros and cons to this kind of approach. Obviously, if you're demanding pitch fees, an agency has to have a certain amount of clout in order to be able to do that. In which case, you could easily marginalize the smaller agencies. So that's one of the downsides. But again, the other thing is that it also creates a greater consciousness on the buyer side that there's creative ideas involved here, there's intellectual property involved here, and therefore there's recognition that there are certain responsibilities on both sides. Let's say, for example, it's a very large pitch, and the pitch includes, say, a multimedia execution, right? So you've got print, you've got PR, you've got digital, you've got mascot designs and all of that stuff. And they may, the client might decide later on, as they've seen 5 different agencies, you know what, we like this agency mainly, but I also like that idea there and that
happens
idea
actually
there.
Yeah, it happens a lot.
There,
happens a lot.
right? Happens a lot. But the difference is, because you're now having this very open transaction about compensation and how much you've paid for people's time and all of that stuff, then it now creates the opportunity where the client thinks, okay, I didn't take that agency's idea wholesale, but I did like that one bit of it, and therefore maybe I can go back to the agency and just get, so how much for the mascot idea? We'll just take that, right? And then all of a sudden that kind of opportunity now
I
opens
think it
up.
all just boils down to human relationships. Business relationships and business transactions are based on human relationships. It's about how well do you know your client, who is the incumbent agency, how close are they, how are you navigating? If you're a newbie agency trying to pitch for a project that has been in this incumbent agency's clutches for the last 3 years, and the management are going to be the same people, what are your chances of getting that project? So I think as agencies, we should all pre-qualify our clients as much as clients are pre-qualifying their agencies. So it is not just a one-way street. It's not just like the clients have their own pick. We have to select what kind of battles you want to fight. For instance, if I'm a new agency and I'm fighting an incumbent agency, I would ask the client and say, have they been delivering the media coverage you asked for? Where are their pitfalls? And see if there is an unmet need that you can fill in there. Because if you don't ask enough questions, you're going to do exactly the same thing, cold. A lot of the pitches that we talk about right now are actually what I deem as cold pitches. They have the 3 quotation box to tick. So they call 3 agencies, and one of them is going to be the incumbent agency. And in such instances, I have actually told the client, you know what, I don't know you very well, but I just want to know, is this to tick your 3 quotation box, or are you really considering us? I'm happy to fill your box. I'm happy to provide you an RFP so that you can go to your procurement and say, you know what, I've got my 3 quotations. This is part of my relationship building with the client.
Wow.
I'm happy to do that. Again, I have to pre-qualify the client. Is it a battle I want to fight? Is it the kind of project that is in line with the company's abilities? Is it our core competency? So you have to find all these things first before you go into the pitch room. I think a lot of what design agencies are doing is that, oh, that sounds good, I can do this, I can present this. My idea is the best thing in the world. But what they don't realize is they have to do the background check first. You know, have they been changing agencies like they've been changing underwear? Because that's also a very bad sign. You know, then the client sounds very problematic. Then that's the kind of research we have to do even before we step into the pitch room.
That, by the way, is a very common industry practice of the client asking for doing an RFP because they need to tick a compliance box internally, et cetera, et cetera. And you know, there are agencies, especially the ones with a little bit more experience in the industry, that know ahead of time and know beforehand to say, is this one of those compliance pitches or is this a real pitch? Right?
Sometimes you even, you know, you get asked, well, we'd like your pitch, but we need a second one. Can you find a competitor for us so that you can do 3 boxes for us?
I've told the client, like, look, I'm happy to do it for you if you really decided on an incumbent agency. You know, I'm just happy to give you like a 5-page proposal that is adapted from something I've done before, you know. But I just want to be able to be in constant communication with you. Yeah.
We're fast running out of time, so I just want to make sure that we establish that last bit of that human communications chain, and that is with the lawyer, before I invite some concluding comments. Vernon made the point at the beginning of our conversation, Cyril, about the reluctance to call a lawyer. Perhaps it is about cost, perhaps it is about not wanting to give up on the personal face-to-face negotiation. Maybe it's simply that, oh, there's too much conflict, this seems like all too much trouble. Are there some common myths that you would like to bust around engaging a lawyer to act on your behalf?
Well, lawyers are not so expensive. I think that's the first point. The second point is that if you do qualify, and the Law Society has a pro bono clinic for IP, so you could go to them and they might be able to help you.
I did not know that.
Yeah, there is. But I think the myth is that when you engage a lawyer, it's not always for fighting. I think more importantly is to the lawyer should educate you of your rights and your liabilities. So you need a lawyer to help you to know your own position. And then the next stage is, do you want to get the same lawyer to take the fight on or work out a settlement? And sometimes lawyers are not all there to encourage you and egg you to a fight, but to try to help you to come to the table for the best negotiation position. Right. And I think that's the best help. Right?
Maybe it's just a signal that you take your work seriously, even if there is no fight.
What I did was, in a recent situation, once I've determined that this was a client that was, well, I probably don't have a future with, but it was nonetheless something that I had to respond to because they made some allegations. And in legal speak, if I don't respond, it's as good as accepting what they're saying as the truth. So as reluctant as I was to respond, I was told by a friend, an ex-lawyer, said, no, you have to respond because otherwise, you're accepting this as fact. So I didn't want to, engage a lawyer, but what I did as a workaround was I sent an email written in a very legal tone and in a very point form as you would if a lawyer had written that letter. I got a lawyer to vet it, but I didn't use a legal firm's letterhead, and I sent that email instead. So that was, I'm not going to advise everyone to do that, but that was something that I did, and I just wanted to share that experience.
Right. Yeah. Any other final concluding comments, Vernon?
No, I think, thank you. I've learned quite a lot today, actually. So
I think it's both sides have to play a part. Like the client side would. I think I highly encourage clients to learn how to give good briefs, to be open to input from agencies in a way that's not such a one-way street thing. To learn more about IP and how it works, because it is going to encourage everyone to give their best. And the agencies would have to learn how to protect themselves. But it's not just protection for the sake of protection, also how to communicate with your clients. Ask the right questions so you can pre-qualify the client, you can put them in the categories and then decide on whether you want to do the pitch. Even before you send your art directors to do it, even before you send the servicing people to do it, do your pre-qualifying first.
Miguel, final comments.
Some pitches are so big that clients hire an agency to manage the agency pitch process, right?
Yeah.
And one of the advantages of that is that you now have a third party involved, who then is is more objective, but is also witness to everything that's been submitted. And I think that's also important. Is that again, a lot of these disputes or a lot of avoiding these disputes is really about that. It's trying to avoid being in a situation where you have a dispute, rather than just being sure of your rights and then being ready to fight it, right?
Yes.
I mean, you want to avoid the disputes as much as possible. So the more is said up front, the more you establish in terms of practice, whether there's a third party involved that then verifies the whole process. I think that's the best for everybody.
Cyril Chua.
Well, I mean, to sum it up, 1, avoid misunderstanding in the case of Vernon. 2, find a compromise. And 3, know your law.
Thank you all for the conversation. We had with us here in the PitchMark studio Miguel Bernas, Cyril Chua, and also from the creative side, we have to, of course, acknowledge the innovators. Among you, we had Vernon Liao and Nan Iliana. Thank you all for joining us in this conversation. Please click like, comment on, share, subscribe, and spread the word on behalf of World IP Forum 2021. I'm Mark Laudy, thanking you for joining us today.